Hello. For those of you who don't know me, my name is Ira Smith, President of Ira Smith Trustee and Receiver Inc. First, the Ira Smith team hopes that you, your family, are healthy, safe, and secure as we continue to move through this COVID-19 pandemic. I want to assure you that the Ira Smith team is fully operational. Both Brandon Smith and myself are holding all meetings and consultations either by telephone or video chat. So by all means, if you have any questions at all about this Brandon's blog or anything else, feel free to shoot either Brandon or myself an email or give us a phone call. We would love to hear from you. Today's Brandon's blog is a review of 2 bankruptcy restructuring cases in the United States that Brandon has already blogged about in the past, and comparing it to the result of a recent Canadian corporate restructuring case. The situation in all 3 is very similar, but the results from the US cases and the Canadian case are very different. So I know you're going to get value from this video and this Brandon's blog. I hope you can watch until the end. Two bankruptcy cases in the United States are Modell's Sporting Goods and Pier 1 Imports. As I said, Brandon had blogged about these in the past. Both companies are big retailers in the United States and filed for bankruptcy protection under Chapter 11 of the U.S. Bankruptcy Code, which is the corporate restructuring provisions. Both Modell's and Pier 1, Modell's was the first, went to court and said to the court, because of the pandemic, all our retail locations are closed. We cannot earn any revenue from them. Our financing is based on cash flows that do not include rent payments being made. And we're providing these cash flows to the court, and we want them approved, and we want specific approval not to make the rent payments. What the court in the U.S. did in both the Modell's and Pier 1 situations is that they suspended the bankruptcy period for several months. So they literally held the bankruptcy restructuring administration in abeyance. They also said that there's going to be, during this time period, a further suspension where the company does not have to make its rent payments. The court was very clear that it did not say that the company didn't ever have to make those rent payments and wasn't waiving the requirement, but was merely suspending the need to make the rent payments. They would be accrued, they would be deferred, and that the company and its landlords would have to make suitable arrangements for these deferred payments as part of the overall restructuring. So that's what happened in the United States. Down below, there are links to the blog about Modell's and Pier 1 if you want to read any more of the details. Recently in Canada, in British Columbia, the court overseeing the corporate restructuring of Quest University, who filed for protection under Canada's Companies Creditors Arrangement Act, CCAA. Quest University went to court in May and advised the court that it had a series of complex agreements with Southern Star Developments. And those complex agreements literally meant, essentially boiled down to, that Southern Star built residences on the university lands, and Southern Star had the ground lease that it could put the buildings on, and then it leased the buildings back to Quest University, and Quest University was making rental payments to Southern Star. And the agreements worked in a way that it was essentially a rent-to-own situation that ultimately one day, through making all the rent payments, Quest University would take over ownership of the residence buildings. So in May, Quest went to court for several things. One was approval of interim financing, and it provided cash flow statements in support of that the monitor signed off on that did not include making rent payments over the summer from June through the fall to Southern Star. Not surprisingly, Southern Star objected to those cash flow statements and Quest's related application for court approval not to make those rent payments. Southern Star said, it's going to prejudice us. We're going to go into default with our lender, Bank of Montreal, who provided mortgage financing. Quest tried several arguments. First, they argued that there wouldn't be any prejudice at all, but the court quickly dismissed that because Southern Star and Bank of Montreal were there to say it will give prejudice to Southern Star and Bank of Montreal, and the court wasn't about to do that. Secondly, Quest tried an argument that is really related to personal property, not real property, in saying that these agreements are really a financing arrangement, and therefore under the CCAA they should be treated as a secured lender, and then we have the right to amend secured lender financing. Well, the court reviewed that very carefully and said, no, that argument applies to personal property, but you can't make that argument in relation to real property. There are various agreements, they're complex agreements, none of them are financing agreements. The court knows what financing of real property looks like, and these aren't those kinds of agreements. So the court dismissed that argument as well. So Quest was left with a request to just not have to make rent payments. The court did a very detailed analysis, looked at case law from amongst many provinces, especially Ontario, where there are a lot of CCAA restructurings done. And the court came to the conclusion that although Quest has the right to not make payments, and Southern Star has its own remedies, the court cannot mandate that Quest not make the payments to Southern Star. The court went on further to say that this summer really doesn't look different than any other summer, because during the summer the residences may not be full. Now, Quest tried to argue that one of the rules of the university is that students must live in residence to attend the university, and in fact about 75% of Quest students are international students, and they also said that they are going to be running a summer semester, and because of the pandemic it's going to be online, therefore it is different, but the court wasn't buying any of it. The court said whatever Quest chooses to do to teach its students has nothing to do with the rental arrangements that Quest has with Southern Star for the residences, and that the court is not going to authorize or approve Quest not making its normal monthly rent payments. So it looks like if other provinces, now I must caution that a BC court decision is not binding on other courts in different provinces, but it is interesting to note how the BC court kept with and even stated that fairness is a huge part of the Canadian insolvency system, whether it is a restructuring under the CCAA, a restructuring under the Bankruptcy and Insolvency Act or a bankruptcy liquidation under the Bankruptcy and Insolvency Act. It doesn't matter. Fairness has to come into play. So unlike Modell's and Pier 1, the court said, in fairness, we are not going to give you that approval, and you are going to have to work it out yourself with your landlord. Very different from the U.S. decision. As I said, not binding on other provinces in Canada, but it is a current look at how one court dealt with the request to not have to pay rent because of COVID-19. So I hope you've enjoyed this video, that you've gained some useful information. I thank you for watching. The Ira Smith team is fully operational. Both Brandon and myself are holding all meetings and consultations either on the telephone or by video. Give us a call, give us a shout, ask any questions you may have. We would love to hear from you. We hope that you and your family stay safe, healthy, and secure.